1.
The Justice of the Appellate Division, 4th Department, hear ye, hear ye, hear ye. All persons having business to do before this court will draw near, give their attendance, and they shall be heard.
Thank you and good morning. The first case for oral argument this morning is People versus Tyleek Fletcher. Oh, Mr. Keene, you're by yourself. Okay.
I am. Good morning. May it please the court. My name is Brad Keem and I represent the defendant appellant. We assert that the trial court should have conducted a minimal inquiry as to the necessity of replacement counsel. We acknowledge that only specific complaints trigger the duty to inquire, but here, appellant was 19 years old. It's his first time in the criminal justice system. And he made it clear that there were some communication issues with defense counsel.
Mr. Keem, didn't he also make it clear that he intended to retain counsel?
He did.
He told the court that, yeah, but I have money. I've been talking to a lawyer in Syracuse. And I think the court accommodated that request, granted a recess so he could use the telephone. And when court resumed a few minutes later, he granted an adjournment for a few days, presumably to allow him to consult with counsel.
He absolutely did. And
the defendant didn't show up on the return date?
I'm sorry, what was that, Justice Nemoyer?
The defendant then did not show up on the return date and had to be brought in by a warrant?
That is also correct. So when he does come back, there's still a question here because there is no retained counsel. So the trial court assumed, I think, that appellant had the wherewithal to retain counsel, but that wasn't the case. So the trial court still has a duty to ensure that counsel, even if it's assigned, that there's a relationship here that can go forward. And these communications that are on the record, the communication issues specifically in terms of he didn't know that he was not youthful offender eligible. He had
they discussed that.
He did without counsel, right? It was between appellant himself and then the trial court.
Yeah, I think his attorney told him that too, that he wasn't eligible for youthful offender treatment.
Right, and that is true. I think it may be telling though that defense counsel said that to him, but appellant felt it necessary to inquire to the trial court about it because the trust was gone. And I think
we'll look at that, Mr. King. We'll look at it very carefully.
Okay, thank you, Your Honor. Unless there are questions on the other issues raised, then we'll rely on our brief.
Thank you very much.
Thank you.
People versus Cameron Isaac. Hi, Mr. Thompson. We're just waiting for Mr. Tyler. There we go. Okay, go ahead.
Thank you, Judge. Good morning. May it please the court. I would like to address, first of all, the second issue of the brief, the Batson issue, because in my view, that's the most clear cut in any event. There is no record support here for the trial court's determination that defense counsel's argument.
Counsel, what was the claimed basis for removing this juror by defense counsel?
His demeanor and his voice inflection, Judge, which obviously.
And didn't the court say, I've observed his demeanor and I don't believe it shows that he was eager to convict, and based upon the tone of willing to serve, he stated that? So didn't he address the very issues raised by counsel?
No, Judge, with all due respect, he didn't. What happened was the attorney a couple of times said, well, I've observed his demeanor and I think, based upon his anxiousness to serve and his tone of voice and his demeanor that, I don't want to have him serve as a juror. And the judge.
And then the court responded, I've also observed his body language and demeanor, And I believe his statement does not show that he's eager to convict, but that he's just willing to serve. So I thought the court addressed those very issues that were raised.
It didn't. You can't tell anything from the record about why the court, other than I've observed it too, and it's my judgment that you're wrong, defense counsel, which, by the way, defense counsel is entitled to be. It's their own gut feeling, unless the court says, here is an articulable basis from which an appellate court can judge my determination that your claim is pretextual, which was never approached here, then the record is deficient. The cases are clear on that. It's the court's obligation to establish that record. The prosecution attempts to assist the court by establishing that record now, but it's too late. It was up to the judge to say, this is why I find your reasons pretextual.
Isn't that exactly what he did? I mean, how could the judge, he verbally expressed what he was observing? What else could he do? Take a photograph of it?
He could have described it in the record. He gave us the conclusion, I don't think your reason's legitimate. I think it's pretextual, but he didn't say why. And it would have been easy to say why. That's what Payne requires, actually, is there be some record established by the trial court for the basis behind its decision.
Again, though, as Judge Joseph just said, he did. He said, I've observed too, and that's not what I'm observing. I'm observing something different. And I don't, as Justice Joseph just said, what else can he do? Take pictures?
Right. He didn't say I observed something different, Judge. He said, I disagree with your observations, counsel. He didn't say why he disagreed or what he disagreed upon. I mean, it would have been easy to say, well, I saw him crossing his arms while he was looking at the prosecution, and he looked open and eager when he was talking to the defense, or something like that.
Okay, I think we have that argument. Do you have another argument?
Okay, yeah, I have a couple more, Judge. Thanks. I'll try to fit them within my time here. I think the next point I would like to raise is that dealing with the police officer expert testimony concerning the jargon that was used here. Now, I don't want the court to be confused about the lack of defense counsel's objection to much of the jargon, which related to drug dealing, because drug dealing was never at issue here. There was no issue that the defendant was a drug dealer, that he was purchasing drugs from the victim who was a drug dealer. So all of the drug jargon passed unobjected to. It was only the jargon that relates to murder and or robbery. And the problem here is, the expert never said, well, there's a fixed meaning for these terms, which is okay if there's some foundation, if there's some basis to say, in my experience, my articulable experience, these terms have been known to mean this: gun, drugs, robbery, that sort of thing. There was none of that here. And the danger, of course, of that is the terms could mean whatever the expert wants to say they mean in this particular case. It's infinitely malleable. And the defense counsel made the appropriate objections. When these terms came up, defense counsel said, I object because there's no foundation. And the court said, well, that's a matter for cross-examination. But it isn't. Foundation goes to admissibility. Cross-examination goes to the weight of any evidence to be given. And here, the weight was great. Although now, in sort of a revisionist theory, the prosecution tries to say, well, the police officers.
Mr. Thompson, one quick question.
Yes.
Are you arguing that there was absolutely no foundation for that testimony, or not enough?
There was not enough, Judge.
Okay.
I mean,
what is enough? Once
Well,
you get to the question of degree, the question is how much?
right. Well, what would have been great would have been if the detective had said, for example, I've been involved in other investigations where this term has been taken to mean guns, or this term has been taken to mean drugs. Make a play has been referring to, as we found from our investigation, a robbery, not a drug deal.
So you would say, Mr. Thompson, if I understand it correctly, that effectively what the police need to do is establish a dictionary meaning based on their experience. That is, they'd have to say, when we hear this, it means this in Webster's, so to speak. It doesn't have to go that far.
No, not necessarily a dictionary meaning, but the common parlance in the community is X, for example, or in my experience, it can mean drugs or it can mean guns. I mean, I've been involved in investigations in the past where it's meant this or it's meant that. I mean, there was no test.
Mr. Thompson, I guess my point is once we get to whether, so you say it's insufficient, so therefore you're saying there is some. When there is some, isn't that then a question for the jury to evaluate it upon cross-examination?
Well, no, I mean, the problem is the foundation, Judge, because there has to be some foundation that provides for the admissibility of these suppositions, which are presumably beyond the ken of the normal juror, so amenable to expert testimony. And there has to be some limitation where the expert can't come in and just say, well, this term means whatever I want it to mean today for this particular defendant. Now, if you'll allow me, I mean, I think I'm probably an expert in drug jargon at this point, after 30 some years of trial experience in this area. In my experience, work always means drugs. I've never heard it been referred to as guns. Now, maybe it is, but, and maybe in this area of Syracuse, that's common parlance. But there's nothing from this record that would indicate that, or that there's any basis other than the officer's desire to obtain a conviction, for example, in this case, to say this.
That's going a bit too far, not his desire to.
Oh, I don't think so from this record, Your Honor. The officer's test or the detective's testimony was highly partisan, as I read through it, and subject to.
Okay, well, go on. We'll ignore.
Thank you.
Put that aside. Okay.
The two quick points, if I could. First, on the severance, I'll leave the court to review the record on the issue of severance and the objections that were made by defense counsel throughout. The arguments by the co-defendant were not as benign and not as unhostile, I guess, to the defendant's claims as they have been portrayed on appeal. But you
don't go so far as to say the defenses were irreconcilable.
I believe they were, Judge. I mean, beginning with jury selection, the defense counsel said, the co-defendant's attorney is putting the gun in my client's hand. And my defense is my client had nothing to do with any shooting or any robbery. So it seems like it's irreconcilable. And that theme was repeated throughout all the way up to closing, where, defense counsel continues to make the same argument about the need for severance and irreconcilable defenses. So, just as an umbrella over all of this, all of these claims, but for the Batson claim, affect and play into the weight of credible evidence determination. And I would argue, first of all, the court's decision in the co-defendant's case relative to weight of credible evidence does not control here. This is a different analysis. There are different issues raised in the defendant's case than those raised by the co-defendant. So I would assert that all of these issues, the police officer expert testimony, for example, about the language that was used, the issue with respect to severance and irreconcilable defenses between the two defendants, all of these go to the weight of credible evidence point. So unless the court has additional questions, I'll rest on the remaining arguments made in my brief.
Thank you. Mr. Tyler?
Good morning, Your Honors. May it please the court, Ken Tyler for the people. I'll just make a point or two and I'll rest on my brief unless there's any questions I can answer. I know this is the second time that I've had Justice Niemoyer and Justice DeJoseph suffer through my briefing in this case. So I'll try to be brief. With respect to the severance issue, they're not irreconcilable. They're just not. One did not require the jury to accept one as opposed to the other. I agree that Mitchell's was more limited because the basis for his liability was more limited. He was the driver. He had no reason to overextend himself into getting into the muck of what Cameron Isaac did or didn't do. With respect to Detective Collins' testimony, Justice Curran, you hit my argument, which was I think there is some foundation. I think that's enough. She testified about her background, years in investigation. She was an intelligence detective at the jails. I don't think she was required for purposes of foundation just to get the evidence in to delineate exactly where her understanding for meanings of particular terms came from. That is the sort of thing that is appropriate for cross-examination as long as there is that minimum threshold of foundation.
Counsel, what standard do we review the judge's determination on those two issues? Isn't it an abuse of discretion?
I think it is. It's an evidentiary question, so there's a great level of deference to the judge there. Just to be clear, I think this was Justice Brunetti. I don't think he ruled that foundation was an issue for the jury. I think what he ruled was that defense counsel's objection was an issue for the jury. And that objection was, well, Detective Collins is tailoring her understanding of the meaning, her view of the meaning based on what actually subsequently happened in this case. That is a question for the jury and how they want to attribute what weight to her testimony. Beyond those two issues, I'm happy to rest on my brief unless there's any questions.
Thank you.
Thank you.
People versus Odyssey Reed. Great. Okay, Mr. Hobbs, go ahead.
Good morning, Your Honors. On behalf of the appellant, Odyssey Reed, I first wanted to just make sure that the court had received a stipulation that has been filed.
Mr. Hobbs, we have that. You've probably heard members of this court from time to time ask the question, be careful, or say, be careful what you wish for, right?
Yes.
Heard that. Just as a side, and for both counsel, I thought this was a very thoughtful approach by counsel, and I just thought I should get that out there. Making no comment on the merits of any of the issues, I just thought that this showed good communication among counsel, between counsel and client. So we have that.
Okay. Thank you, Your Honor. I'm glad that's resolved. The other two remaining issues in the case, obviously, are the consideration of the claim that there hasn't been consideration of a youthful offender adjudication, and also a request for a sentence reduction. That
seems to be sort of conceded, correct, with respect to a hold and remit approach?
That's correct. That's correct. And unless the court has any questions about what to do with that, I'll rest on the briefs and the people's concession. Thank you.
Thank you.
Good morning, Your Honors. I will also rest on my brief, absent any questions.
Thank you both very much.
Thank you.
Thank you.
Michelle Signori and versus Michael Santaro. I don't even think I came close to pronouncing that correctly. There you go. Okay, Ms. Campbell.
Good morning, Your Honor. Linda Campbell for the appellant Michael Santoro. I think that the issue in this case can be looked at in two ways. One is the violation of the principle of party presentation, and the second one is an abuse of discretion on the part of family court.
Ms. Campbell, real quick. How is it that we can say that the court abused its discretion, assuming that's our standard of review, when it followed the law? And even if you were to concede that it didn't abuse its discretion, I suspect you would argue that we have the authority to exercise our own discretion, even if we found that the court below did not abuse it. Is that accurate or no?
I think so, Your Honor. I know that the third department has stated that it has never found an abuse of discretion when a court has dismissed objections. The problem with it is that there's consistency among the departments that courts can exercise their discretion in shall we say, ignoring the terms of the statute. So to me, it would seem a logical conclusion that if you can exercise your discretion to ignore, then not to ignore could, on the flip side of the coin, be viewed as an abuse of discretion. And while various courts may not want to look at a situation as an abuse of discretion, it's our position that in this particular instance, it was an abuse of discretion. Principally because in this particular instance, there was no prejudice. Mr. Alderman's client, Mr. Alderman, filed a response to the objections of Mr. Santoro and filed his own objections, which were considered. The court did not alert anyone to the fact that it had any intention of itself, sua sponte, dismissing the objections. And by acting as the court did, the court the family court has deprived Mr. Santoro of any review of his challenges to the support magistrate's decision and ultimate order. This court can't review.
We understand that, Ms. Campbell. You know
I'm
that.
sorry, Judge, I can't.
We understand that.
Okay, so I think that there is an abuse of discretion here. If you can say it's not an abuse of discretion to ignore, then the flip side would necessarily be that it is an abuse of discretion. But beyond that, you have this principle of party presentation out there, which we don't call it that in New York State. I think our closest analogy would be the preservation rule. And as this court is well aware, when the parties frame the issues in a litigation in the court below, this court is pretty much bound by the framework that was created in the court below. It can't reach out, and I would cite to this court La Fontaine and Concepcion for the fact that this court can't reach out on its own and say, well, we don't really like the way you decided that particular issue, so we're going to decide it differently, because the parties have the obligation to present to the court the issues. Then when we go the next step, which is the Court of Appeals doesn't even have jurisdiction over non-preserved issues. So it would seem that by definition, that this principle, this preservation, if you want to call it that in New York, principal party presentation at the Supreme Court level, that the parties have the obligation to frame the issues that the court has decided.
Ms. Campbell, on that point, you're probably familiar with case law from our department and elsewhere. It's based on Scholes versus Meager, where when a court grants sua sponte relief, that is, there was no notice of motion requesting this relief and there was no relief request in the papers, the Scholes versus Meager would suggest that the party that was injured by that sua sponte relief has to go back and make a motion to vacate the ex parte relief or sua sponte relief. However, here we don't have that, right?
Well, we do in a fashion, Your Honor.
Under the Family Court Act, basically you're not moving for anything, you're just filing objections. So to your point, if I understand it correctly, that Scholes versus Meager issue is not here. Instead, it's a preservation issue. And because the other side didn't preserve it by making that argument, it's really not before us, and the court you would say, was an error on doing that.
Well, Your Honor, if I might, there was no motion to vacate, there was a motion to renew, and that motion was denied. So we've tried to get this back before the trial court, and we haven't been able to do that. So, you know, we're sort of between a rock and a hard place here. We cannot bring the issues to this court because we've been precluded from bringing them to the trial court below.
We understand that, Ms. Campbell.
I would also point out one little aspect here that I think is somewhat important. 439E of the Family Court Act, which is the section here to which the court cited, only affords family court 3 possible avenues by which it can decide objections. The statute specifically says it may remand for 1 or more issues of fact to the support magistrate, not done here. 2, it may make, with or without holding a new hearing, its own findings of fact and order, again, not done here, with respect to Mr. Santoro's objections. And 3, it may deny the objections. Family court could have, if you will, ended up in exactly the same place that it did end up in without infringing upon Mr. Santoro's right to review by this court by simply denying the objections and making exactly the same ruling. So,
I understand that.
however the court looks at it, I think that this should be remitted to the family court. Thank you.
Mr. Alderman?
Yes, thank you. Good morning, Your Honors. May it please the court, I represent Michelle Sigourney in this proceeding. And as I think the court recognizes, this is a matter of whether or not the family court judge abused her discretion in dismissing the objections. Basically, there are, in the cases that have been dealing with this section of the Family Court Act, been really three scenarios that the courts have been addressing. One where there's been an granting of the, or an exercise of discretion, allowing the failure to comply with the Family Court Act to nevertheless hear the objection, then rule on them. And that has been affirmed by the appellate courts. The second scenario is where there's been a failure to comply with the section of the Family Court Act. And there's been reasons given by the objector as to why there was a failure to comply. There was a flooding in Binghamton. There was a failure to advise the party as to the correct times when the family court clerk's office would be open or closed. And the courts, the appellate courts have in those cases reversed the family court judge when the family court judge has exercised its discretion in nevertheless dismissing the objections. The third scenario is the one that we have here, where there was clearly a failure to comply with the family court section, but no excuse or reason was given by Mr. Santoro or his counsel for the failure to comply. And in that scenario, the appellate cases are pretty clear. They will say that it is within the family court judge's discretion to either dismiss or to hear the objections. Now, I think,
Counsel, do you think that this court should consider the issue of prejudice and consider the issue of, the really de minimis failure to follow the statute perfectly?
well, I've got two responses to that, Your Honor. First, there's been no case, no appellate case that has caused a reversal of the family court judge on the sole basis that there's been a lack of prejudice to the non-objecting party. But more significantly, I think, is the case law that was set out in the Riley decision by the Third Department. And in part, the Third Department in that case said, we have never held that it is an abuse of discretion for a court to require adherence to statutory requirements, which basically is saying that the family court judge, unless there's a reason given for the failure to comply, the appellate court should not overrule the family court judge's determination that there's, in exercising its discretion, that they dismiss the objections.
Mr. Alderman, does it make a
Yes.
difference that you didn't raise it? Did you waive that defect by not raising it?
Well, we didn't know that, and I can speak personally, Your Honor. I checked personally with the family court clerk during the 30-day period to see, once the objections had been filed, whether or not there is proof of service that had also been filed, because our office had previously been involved in a similar situation. And I was told personally by the family court clerk that all of the papers had been filed. So I had no idea that there was that failure until I received the family court judge's decision. So the fact that an issue wasn't raised by myself on behalf of Mrs. Sigourney, because we had no idea that there had been a failure to comply with the Family Court Act. Now, one other point I should like to make, and that is, as Ms. Campbell indicated, there was an effort by Mr. Santoro and his counsel to rectify the situation by making an application under CPLR section 2221D for leave to re-argue. And the important thing to remember is at no time did either Mr. Santoro or counsel provide to the court any explanation, any reason, any justification for the failure to comply. Wasn't even a question of Mr. Finocchio saying that it was an inadvertent failure. Made no reference to the reasons or the cause of the failure to comply. And my position on behalf of Mrs.
Mr. Alderman, just a factual question. Is the motion to re-argue or renew, whatever it is that in the record?
It is not.
Okay.
But it is, yeah, and I certainly as an officer of the court, and I think Ms. Campbell also recognized that such a motion was made, and I participated in that, and there was never any effort by Mr. Santoro or counsel to explain.
Again, no, that's not in the record, right?
Thank you.
Thank you. In the matter of Lamarick, Ontario County Department of Children and Family Services. Okay, go ahead.
Good morning, Your Honors. Danielle Blackaby, Hiscock Legal Aid for Appellant Mr. Jonas S. This neglect finding should be reversed and dismissed, at least because the conditions had been ameliorated. A prior neglect finding does not create a presumption of derivative neglect, only admissible evidence, which alone is typically insufficient to justify a derivative neglect finding. Jonas completed every single service required by the January 2016 stipulated neglect disposition. Jonas
Is
no
it
longer
not a fact, counsel, that the anger management services were not completed at the time of the filing of this petition?
the anger management services had not been completed when the petition was filed, but they had not been required of him until about, I believe, a couple weeks before the petition itself. And the underlying neglect petition here, or order here, is from nearly 2 years prior.
And there seems to be a major dispute about his participation or failure to participate in New Steps. Did you want to address that?
Sure. So the New Steps program, he had actually started it in December of the year, about a little over a month.
Petition, sure.
Yeah, a little over a month after the petition, he started the program. And it was actually, the waiting list was more than 4 weeks, according to the county's testimony. And so that's basically as soon as he could have started that program after it was actually required of him.
When was he first informed that he was required to participate in that?
He had been informally asked to participate in that program, I believe in June of the year the petition was filed. So that'd be about 4 months before, but it hadn't been required.
No, correct me if I'm wrong. I thought the first time I saw that was in a letter, Exhibit D, that was dated in October.
It's entirely possible. And there wasn't any, to my recollection right now, very specific testimony as to when the county had actually asked for these. And so it was piecing a lot of it together between what they said they asked for and what they actually sent in these letters.
No, is the court entitled to consider the fact that just a few weeks before this petition was filed, that there was another order of protection issued in this matter, directing your client to refrain from contact? Does that demonstrate that the underlying conditions that led to the neglect of the first 3 children were really never addressed?
I don't think so, Your Honor. The subsequent, my recollection of that particular order is that it was part and parcel of this continuing underlying supervision order, that they just continued it. And that's typical of a family court. They don't typically drop those orders of protection.
Well, but there was a new one issued, wasn't there, in October, just before the filing of this petition? I'm
missing that in my memory right now, but I'm sure Your Honor is correct that there was. And as to that order's relevancy, I don't think it's particularly relevant, because if you look at the facts underlying the circumstances of Jonas's life, he was no longer in contact with Erica. He no longer lived with her. There hadn't been any allegation of domestic violence style conduct, which here was simply limited to arguments, for about 2 years. And he
Well, there were
completed
16 incidents, but not all of them were just arguments. Weren't 2 of them physical?
2 of them were key snatchings, and there was 1 shove. This is not by any means, I think, the worst instances of DV that could have happened in cases that we typically see, but most of this was simply verbal arguments, and he remedied that by moving away from the person that was where the friction was remedied when he moved out, and completed parenting classes, domestic violence classes, and there was no evidence of continuing domestic violence.
But if the burden shifted to him to show that it was not currently a problem, don't we have to defer to the credibility finding of the court that he didn't establish that?
No, it's not. The burden doesn't shift to my client. My client's never required to prove he did not neglect his children. It's the county's burden to prove that he did. And in this case,
if they've established that and they said he needs to take these steps in order to show that this doesn't exist, doesn't he have some responsibility to show it's not a current problem? And the court didn't feel he did that. You're saying he has no obligation to show that problem that existed before doesn't continue.
I'm saying the court
ameliorated it.
I'm saying that the court was incorrect in its assessment of any showing that is required that he'd ameliorated anything, because it consistently, and the county consistently, and the attorney for the child consistently insisted that he had been required to participate in anger management and steps to protect since 2016. And this is just false. It's not in that order. It's nowhere until at most 3 months before the instant petition was filed, which stings of bad faith to a certain extent, because he'd completed all the other programs. And so where you ask him to complete another program, it's logical to assume that he would be willing to participate. And he did in fact participate, and he did in fact complete anger management. And as to specifically the Steps to Protect program, that was arguably not properly required of him in the first place. It wasn't based on any misconduct by my client. It was based on the failure of the foster parent to protect his child from sexual advances of another foster child. And the lower court recognized this, I think, when it stated that it wasn't even going to require the programming of him if for some reason he was unable to participate for the program reasons. But nonetheless, he had started the program, and where he'd completed the other programs in the past, it was improper of the court to consider that he wouldn't participate and finish the program.
I think we have that.
Sure. And so for these reasons and the other reasons in our brief, we would request that this order be reversed and the petition dismissed. Thank you.
Thank you. Okay, Mr. Chaplin.
Good morning, Your Honors. And may it please the court. My name is David Chaplin for the petitioner respondent, Department of Children and Family Services.
Sure. Can I ask you a couple of questions at the outset here? Sure. As I understand it, family court found that the father came up short in 2 areas, that he didn't finish anger management and that he didn't participate in new steps. Is that correct?
That's correct, Judge.
All right, and the anger management was in fact completed about a week or so after the petition was filed. So there was substantial compliance there. About new steps, where is it stated or where was he directed and when was he directed to participate in that program? The first thing I see in print is a letter that he received in October telling him to participate in new steps. That's Exhibit D. I couldn't find anything else.
Yes, Judge. I believe the one before that, prior to that official recitation in the letter, was we got through testimony of, it was Kathy Diana and the caseworker.
Yes, it was their understanding that he was required to participate in it, but the only I mean, there were 4 letters sent to him, exhibits A, B, C, and D. Exhibits A, B, and C did not reference new steps. Only
That's
exhibit
correct.
D did. And that
That's
letter
correct.
was dated in October 2017, shortly before the filing of this petition. And then in fact, in response to that letter, it appears as though he engaged in that program in December. So did he comply or not?
No, Your Honor, he did not comply.
Why not?
Well, he was on notice of new steps in August, I believe he even admitted to in his testimony.
Well,
And
the first letter is dated in October, isn't it?
right, but the letter isn't the only notice that the appellant had in this particular instance. He had notice prior to the letter being, that specific letter being sent to him, of his need to complete the program, and he failed to reach out to the program to get it started. The wait period wouldn't have been an issue had he reached out at the same time his his ex reached out for the initiation of the program.
The services that were required for his wife were far more comprehensive than him.
Of course.
Okay.
Yeah.
Do you have anything further?
No, thank you, Your Honors. At this time, we rely on our brief.
Thank you. Mr. Greenberg? Mr. Greenberg?
Good morning, Andrew Greenberg, appellate attorney for the child. Judge DeJoseph, asked you a questions on timing. In the anger management referral, I think we have in June of 17 in the record. I think that that's one of those letters on page 538 in terms of the anger management. In terms of the new steps, there is some what I would acknowledge is some messy testimony from the counselor, Catherine Diana. So I noticed page 235 in through there, where the referral comes in, and the referral comes in for both mother and father, and the mother does contact, the father doesn't contact until December, she testifies. And so there's some assumptions that are made there about the father having been contacted, but I think you are right that it is that October of 2017 letter, I think on page 540, where we first see in print a letter to the father here that says new steps is one of the things we are requiring. Why I think that is not particularly of importance, those dates, is that we had in effect already, we had a series of permanency orders, right? This had been about 18 months from the original neglect finding. And we had, I think, 4 permanency hearings. The most recent one was in October of 2017. In that permanency order that was stipulated to by the respondent in place before the filing of the derivative neglect petition, the court found that it was unsafe at that point to return the older children to the father, that the father's visitation still over that whole 18 months had never been unsupervised, and it still needed to be supervised with those children. And the court found that services continued to be needed, including anger management and the New Steps program. So that was all in place, stipulated to by the father. I think what we see on the appeal here is arguments that if the father had wanted to make should have been made as part of the permanency hearing. Instead, for whatever reason, the father stipulated that the father was still not in a position to have unsupervised visits with the older children, that the father still needed services to resolve those issues, and once that's in place, and proximate in time, especially to the filing of the petition, then the burden does shift to the father to show on the derivative neglect petition that the conditions have been ameliorated. And here there just was, the father was in a very difficult position to make that showing because he had just stipulated to all the things that were still needed to be done regarding the older children.
And Mr. Greenberg, was there in fact a new order of protection issued in October?
Yes. So in October, at the time of the, yes. So number one, yes, it's in the record. I don't have the page number, Judge, but yes, there is in the record, the family court issued a new order of protection, stay away order from the mother, requiring supervised visitation. So the court at that time in October, just 3 months before the filing, said that was needed. There were also 2 other order of protections still in effect from the IDV court and from the city court. So there had already been all these court determinations that conditions were not ameliorated, that the father still needed services, hadn't progressed, and then the child, my client is born, and petition is immediately filed. So
Thank you very much.
thank you.
Jamie Mass versus Gerard DeSimone. Okay, oh wait, where's Mr. Brew? Oh, I don't have Mr. Brew. Mr. Thank you. I'm really not talking to myself. I know that's what it looks like. Okay, go ahead.
May it please the court. Good morning, your honors. My name is Julie Iacobucci and I represent the defendant appellant in this matter. I would like to get down to the heart of why we are here before your honors today. We are here because the lower court's order denying defendant appellant's motion in limine will unfairly and improperly allow unreliable, false, and misleading evidence at the new trial.
Iacobucci?
Yes.
I'm stuck on sort of what I think is the gateway issue about whether this order denying relief affects the substantial right of the parties. First, can we agree that the court, depending on the testimony at trial, could change its view of this issue, correct?
Your Honor, I believe that the testimony that the expert witness should not be allowed to testify at trial because the unreliable nature in which he would testify shouldn't be presented before the jury.
Iacobucci, I understand that. I'm asking you kind of a twig on the end of a branch question, I realize, but the court at trial, based on how the evidence comes in, could change its view and preclude the testimony in part, correct?
That's correct, Judge. There could be objections at trial which could ultimately preclude the testimony.
And
However,
this issue doesn't affect liability either, correct? That's already been established.
that's correct. What's going to happen at the new trial is solely the issue of the future economic work loss of the plaintiff. We were previously before this court and it was sent back to the lower court for a new trial just on that issue.
I recall. Ms. Iacobucci, as a practical matter, if this was such a substantial issue, wouldn't there have been cross-examination at the first trial on these Gamboa tables, however they're pronounced, CPS, ACS, or wouldn't the defendant have put in proof opposing that? So how do we look at this as affecting the substantial right when in the first trial, defendant put in no evidence, did not cross-examine on this issue, and did not previously raise this issue, which to my understanding was clearly presented?
Your Honor, respectfully, at the first trial that we did cross-examine the expert witness. We also did object to his testimony. The defense did not have an expert of their own at the first trial. As it has been sent now for a new trial, we have retained our expert, which has advised that the Gamboa tables are an issue and that this data, the methodology that the expert is using an unreliable.
Right, so that can come up at the trial, right?
Respectfully, Your Honor, we don't believe that this testimony should be allowed before the jury whatsoever, as it could severely prejudice the defendant appellant if it's presented at all. What the information that we have shows that the scientific methodology that the expert used was unscientific, and it's not generally accepted in the scientific community. And at a minimum, we would say that we would respectfully say that this matter should be sent down to the lower court for a FRI hearing so that it can be determined as to whether the methodology used was scientific and should be reliable whatsoever.
Okay, thank you.
Thank you. Additionally, specifically regarding the methodology that was used, again, we would submit that the expert should not be allowed at all.
I think you've made that point.
Okay. And just with regards to what has been relayed in our brief, I would just like to note that there were only several arguments that were presented to the lower court by the respondent plaintiff in opposing our application. Those points that were made were arguing just the doctrine of stare decisis and the law of the case. Some of the other arguments are newly presented here before your honors for the first time, and we'd ask that those arguments not be considered as they cannot be first argued upon appeal.
Thank you very much.
Thank you.
Okay, go ahead.
May it please the court. Good morning, your honors. Ed Markarian for the plaintiff. Your honors, the appeal should be dismissed. This is an appeal from an order denying an in limine motion. Those are not appealable except in a rare instance where causation is at issue on a novel theory. We don't have that here. It's a garden variety in limine motion. As the court has discussed this morning, the issues, the order is just advisory. All of the issues can be represented with more proof at the trial as to whether the testimony is admissible. And that's why in limine orders are not appealable. Also, if the court considered the merits, the court properly exercised its discretion. The argument below was that the expert affidavit from the defense goes to weight, not admissibility. And that's the correct argument. The testimony was found to have a foundation at the first trial. This court referenced the testimony in remitting the case. So it goes to weight, not admissibility. There is no substantial right here that's implicated. It's not that it wasn't preserved at the court below. This is a new issue, an appellate issue, and that's whether there's a substantial right that's implicated. It's a jurisdictional point. And then when you look at the argument, the Gamboa argument, there's no reference to Gamboa in the plaintiff's expert's testimony in any of his reports. I submit it's an illusory argument, at least at this stage, and certainly does not implicate a substantial right. So we would ask that the appeal be dismissed, or alternatively, that the order be affirmed.
Thank you very much. Zimmerman versus Jarek Builders. There you go. Ms. Gross.
Good morning, Your Honors. Olivia Gross for the Appellate, Southwest Marine and General Insurance Company. Commercial general liability policies have been uniformly understood by our courts to be litigation insurance. They afford a defense. They afford indemnity in the event that there is a verdict or reason to settle. That's why our courts have uniformly held that everything in a claim file is presumed prepared in anticipation of litigation and subject to privilege. From the moment the insurance carrier learns of the claim, everything the insurance carrier does, unless it is investigating the insurance coverage, is in anticipation of litigation and
okay, Ms. Gross, let's stop right there. Okay, you said the words investigating coverage. It's my understanding from the record that you were investigating coverage at the time that many of these documents were prepared. You hadn't accepted the claim, meaning that you hadn't decided yet whether or not you were going to, take on the defense and indemnity for this incident yet. In fact, there's a letter, as I recall in the record, that at some later time indicating, okay, now we've accepted this and we will defend you on this claim.
Your Honor, I believe that that is a misconstruction of the record, but there was no investigation into coverage at all. There was no claim. An accident occurred. The next day, Mr. Jurek calls his insurance carrier and says there's been an accident. Lisa Kim submits an affidavit that says, and she has an email that shows that she spoke with Donna Jurek and she said, listen, I'm going to send an investigator tomorrow to take measurements and photographs. And then approximately 4 days later, there's testimony by Mr. Jurek at his deposition that in fact, he observed the investigator taking photographs and measurements. That's not an investigation into insurance coverage.
Wait just a minute.
Okay.
Sorry.
You know, we've actually, you know, seen the documents, so we do know what they say. I was going to try to keep you from describing the documents too.
Sorry.
No, that's okay. But the record is pretty clear that you had not decided, you meaning your insurance company that you represent here, had not decided to take on this claim and defend this claim until some later time.
That's not true, Your Honor. There was never a question. There was never a question about insurance coverage. The cases that counsel cites and that he relies on, where he says that the standard is whether or not a claim is going to be accepted or rejected, every single one of those cases is an insurance coverage case where there was a denial of coverage or reservation of rights. There was never
the insurance company had not formally accepted this.
There was no claim at the time, Your Honor. How does an insurance company accept a claim with no claim pending yet?
All right,
I have a
let's
comment.
take that one step further. There was no claim pending yet. Why are we to accept the premise that, in fact, then everything that you did was in anticipation of litigation when no claim, in fact, had been filed at that point?
Because that's the business of an insurance company.
Okay, don't they have other business reasons to investigate the claim?
There were no other business reasons. And all of the cases that are cited by plaintiff's counsel, if you take a really good look at those cases, Crazy Town versus Brooklyn Union Gas, Peralta versus New York City Housing Authority, Ketchmajian versus Budget Rent-A-Car.
We looked at all those cases.
Yeah.
In every single one of those cases, it was a self-insured defendant who was doing its own investigation. You don't have that here.
Well, excuse me. I mean, but this is,
I have one issue that I'd like to raise. And this seems to be handled by the textbook form. There was a demand made. The demand was not ignored. A privilege log was submitted. The documents were submitted to the court for in-camera review. Again, just according to textbook, the court made a determination after doing an in-camera review. Aren't we now looking at an abuse of discretion standard?
No, Your Honor. You're looking at the standard of whether there is no evidence in the record for this judge to have abused her discretion. There was no fact on which she was relying in order to see whether or not the material was prepared in anticipation of litigation. Her ruling was that she looked at these records and there was a safety purpose. There was no safety purpose. I don't know where she got that from, because the railing, according to the testimony of Mr. Jurek, had already been replaced. It was already put there. And the only basis on which privileged documents in a claim file can be disclosed is if there's undue hardship. And I think we could all agree there is none. Plaintiff's counsel's argument is that he wants to see why there are inconsistencies in the testimony. The plaintiff's brother-in-law testified that the railing wasn't there. Mr. Jurek testified that an EMS worker told him that they removed the railing. An EMS worker testified that the railing was removed by them. So he says, not that there's undue hardship, because all of these people were at the scene on the date of the accident. What plaintiff is saying, I want to see what's really in that claim file so I could fish for information and see why these inconsistencies exist. He's not saying he needs it for the case. He wants to resolve inconsistencies. And that's not an appropriate basis to eliminate a privilege that attaches to a claim file. All of the
I
cases
think we have that argument.
The other thing that I just wanted to point out is that Southwest Marine clearly is not the defendant here. The business purpose of an insurance carrier is underwriting policies of insurance and then adhering to the policy of insurance by affording its insured a protection without defense, preparing for litigation. If you were to accept the argument that everything is discoverable from a claim file until there's a decision made, if a plaintiff does not bring a lawsuit for 3 years, then you're saying that everything that's done in that 3-year period is subject to disclosure. An insurance carrier is not going to engage in investigation and is going to be reticent to afford an insured a defense if any notes in its claim file and if its investigation have to be turned over. I think we would all agree that if the plaintiff went to his own counsel's office before the 3 years before he starts a lawsuit, or the 1 month.
I think we're going off the rails here. We're not talking about 3 years here, so.
No, Your Honor, but it's several months, and the law that applies is not going to be applied based on timing. It could be 3 years. It could be 1 week. It could be 1 month. The question is whether or not the information that's gathered by an insurance carrier, which is not for its own business purpose in underwriting, but is to protect its insured, to prepare for a defense, ought to be disclosed. And we submit that it's error to state that the standard is whether or not there was a decision to disclaim or not. It was never an issue here. There was no lawsuit pending at the time.
I think you've made that point. Do you have anything further?
No, Your Honor, we'll rest on our brief.
Thank you. Mr. Hogan?
Thank you, Your Honors. I think what's significant here is that the carrier really is not disputing the substance of the lower court's finding that there was a non-litigation purpose, at least in part, for the creation of the documents. There was a safety purpose involved. They're making a much broader point. They're saying just because we're an insurance company, everything we do from the moment we learn of an accident is automatically per se privileged, and we don't even have a burden to show that factually that that's correct. That's not what the law is. The courts have recognized that insurance companies, they have regular business and they have litigation related business. And that's what our subpoena was narrowly drafted to capture. We said, produce to us the documents that you reviewed before you made a decision whether or not to accept the claim. They said, well, there's 20 pages of documents here, but you know, we say they're privileged. And all we've done is simply hold them to their burden on that. We said, you've got to show that they were done solely in anticipation of litigation. They went before the trial court, and the trial court made the decision that she made. And I think Justice DeJoseph is right that this is an abuse of discretion standard that this court is reviewing based on an in-camera review on an issue where the trial judge has a lot of discretion to make these determinations. And it's not correct that the only cases that we're relying on are first party cases. We've cited a number of cases, and I know the court's familiar with them. Just to mention them briefly, the gist of it is just because the information is compiled by or gathered by the insurance company, that does not per se render them privileged. And it's not all self-insurers either in those cases. I don't think you can deduce that from the opinions. There's the Agavino case. That was a case against Taco Bell. The employees called the insurance company and gave statements after somebody said they got sick from one of the drinks. The court said just because they're compiled by the insurance companies, there's still a burden that they have to show, and they haven't shown it. And there's other cases. The Sigalakis case is another one.
We've had the cases.
Right. And so, Your Honor, I think it's a straightforward issue, abuse of discretion standard. And beyond that, I would just rely on the briefs.
Thank you very much.
Thank you.
Tanksley versus LCO Building LCC. Mr. Lenhart?
Good morning. May it please the court. I represent the framing subcontractor on this project, Blazuniga. My opponent represents the prime framing contract. The plaintiff was a roofer and was not involved with either of our clients' work. The plaintiff has never sued my client. The plaintiff's claims against my opponent here today, SAB, were dismissed without opposition. There's no allegation in this case that the building that was framed by my client was not framed properly.
Sir, does the indemnification clause at issue here have anything to do with negligence?
It does not have a negligence term in it, Your Honor.
And the language seems rather broad to me, arising out of the work. And that's the operative clause, isn't it?
That is the clause on which the trial court granted summary judgment to the party seeking indemnity. So in order to do so, the court would have had to find that the parties had an unmistakable intent for that contract to require indemnity in a situation like this. And in this situation, arising out of the work, this accident did not arise out of my client's work, and certainly did not arise out of my client's work as a matter of law. The testimony in this matter is undisputed that the plaintiff was a roofer, not a framer, which is what my client did. Testimony is undisputed that
your client's work was still ongoing, correct? Your client wasn't done framing.
Exactly, Your Honor. And my client had no obligation to protect the other trades on the job site. That was not part of the contract.
Your client did construct the opening that the plaintiff fell through. Is that correct?
Yes, Your Honor.
Okay.
And it was the testimony of the plaintiff's employer that he admitted that he was obligated to provide for the safety of his employees. It was the testimony of the construction manager that it was obligated
I can see this is all relevant from a negligence perspective, but we're talking about an indemnification clause that I think is somewhat broad, arising out of the work.
And I guess maybe your use of the word broad, I would like to turn to the word ambiguous, Your Honor. And I think it's at least a question of fact as to whether the phrase arising out of the work encompasses anything that has to do with the structure that we built.
Didn't the Court of Appeals address that term in the Worth case? They defined arising out of the work as originating from or having a connection with.
They did, but the Worth case also stated that merely being the situs of the accident does not qualify as for arising out of the work. And that's what the allegation is here. And it's what you've been questioning me about. Isn't it true that you built the structure from which the plaintiff fell? Yes, but that's not enough. The Court of Appeals affirmed the Appellate Division in Brown versus 2 exchange, in which the court said that when you build a structure, you don't become the virtual insurer for everyone that might happen upon it later.
But you are bound by the terms of the contract. And I think it's even broader. It's not just which may arise or which may have been alleged to have arisen. There's no question it's alleged here that it rose out of your client's work. And there's no question that your client's work wasn't done yet.
Well, that's where I disagree with you, Your Honor. I think there is at least a question as to whether it arose out of our work. If you were to apply,
we're going to have to look at very carefully. That's what you've been going at. So
just on that point, Your Honor, just one last point. If you were to adopt the standard that merely constructing the structure from which the plaintiff fell, that would be akin to saying that if you built a new home and someone opened a window and fell out the window, even while other work is going on, then whoever installed that window is responsible for that fall. That's not the situation here. I think it would be helpful to ask yourself, what should my client, the framer, have done? He built the skylight he was asked to build. He covered the hole with a piece of plywood and wrote "danger hole" on it. He was present at the job site at the time the accident happened. He told the roofers, including the plaintiff's employer, not to go up onto the roof. short of exerting force against these other people, what was he to have done to have avoided?
Perhaps what he could have done was look for a tighter indemnification clause in the contract.
Well, Your Honor, I don't think that the trial court, nor could this court rule as a matter of law that a jury is not entitled to determine that the accident did not arise out of my client's work, but rather the accident arose out of the fact that the plaintiff's employer ignored instructions not to go up on the roof.
Okay,
Or
I
that
think,
the accident, I'm sorry, Your Honor.
I think we have your argument, I think.
Just one last point, Your Honor. So the indemnity agreement has been enforced in this situation to not only require indemnification by my client of SAB for the first party action commenced by the plaintiff, which is now dismissed, but also to cover cross claims raised by the property owner against our superior contractor, SAB.
You're speaking of LCO now, sir?
Yes, I am, Your Honor. Thank you.
You know, I know you briefed it, and there's a problem here. LCO opposed that motion. Is that not correct?
Yes, they did.
Their opposing papers are not in the record. I'm not sure how this court can evaluate this issue because their papers are not in the record.
I believe their papers are part of the record,
Look at
Your
page
Honor.
671. I think it's 671.
Yes, Your Honor.
Are they there?
They're entitled the affidavit of Rob Leary. It appears that it's the affidavit of Robert Baxter.
It's not there.
That may be an error in the record. There may be there are multiple.
But an error in the record, we have to go by the record.
All right, Your Honor. I will see if that can be fixed. On the other hand, LCO was on notice of this appeal and they filed no opposition to it. And there really is, on the merits, there is no allegation that my client agreed to accept the contractual obligations that SAB agreed to accept from other parties.
Okay, I think we have that. Thank you.
Thank you.
Mr. O'Malley? Mr. O'Malley, you need to unmute yourself. There you go.
Can you hear me now?
Yes.
Okay, just a few brief points that really respond to the questions that the court had. As far as whether the incident is alleged to have arisen out of Blas's work, it certainly does. And it certainly did arise out of Blas's work because it's not just the situs of the injury. The plaintiff alleges that the opening in the roof was the injury-producing condition, and the opening of the roof with an insufficient safeguard in place to prevent the plaintiff from falling. So while there may be other theories and there may be other allegations as to other contractors that may have been responsible for the fall itself, the injury-producing condition, negligently or not, as Your Honor recognized, it is not relevant under this provision, this identification provision. The injury-producing condition was created by Mr. Lenhardt's client, who was still present and engaged in the ongoing work. As far as the argument that we would essentially be ensuring, or that Mr. Lenhardt's client would essentially be ensuring this, well, that is essentially what Blas Zuniga agreed to do, is to the extent that their work, anything that happens incident to Blas's presence on the site in Blas's work, they are essentially ensuring SAB under that identification provision. Now, if the incident happened somewhere or was caused by something that was not incident to Blas Zuniga's work, then you would have a different argument. But that's how broad the language here is. And there's no argument from Blas that language is unenforceable due to its breadth. And so I would agree that it is quite broad. And as far as whether the language arose out of Zuniga's work is ambiguous as opposed to just broad, I would agree with the court that the Court of Appeals has addressed that exact language and has not found it ambiguous, and in fact has defined it in the broadest possible sense in the Maroney case, such that it's directly applicable here by saying incident to or originating from or connected with. I think the Court of Appeals made it quite clear that we interpret this as broadly as we possibly can, and it certainly renders it applicable to these circumstances. As far as the retroactive application of the provision, here, this is a classic case of two parties that happen to sign a contract at a later date, but who had
they did that all the time, correct?
They do, and there are elements that have to be satisfied, and here those elements are satisfied abundantly. I mean, it bears the date prior to the accident. It goes above and beyond what's required to establish retroactive application. Mr. Zuniga was quite candid in his testimony that this was the contract they always signed. He had every intent to sign it. He didn't get around to it, but eventually he did. And so unless the court has any other questions, I would rely on our brief.
Thank you.
Thank you.
Rosado versus Rosa Copland Jewish Home and Infirmary. There you go. Okay, Mr. Hudson.
Morning, and may it please the court. Timothy Hudson for the plaintiff. Your Honors, the trial court here erred in granting summary judgment. We would ask the court to reverse that for two reasons. First, the moving nursing home did not meet its initial burden as they were required to do. And second, even if the court finds that they made their initial burden, yes, Your Honor.
Before Supreme Court, it looks to me like you did not argue that defendant failed to carry its burden. You went right to arguing questions of fact, correct? I'm looking at the affidavit submitted in opposition to the motion. Looks to me like the answering affidavit was directed entirely at raising a question of fact, correct?
Well, Your Honor, the responding affidavit was aimed at raising a question of fact, but I would submit to the court that that a movement has a burden to show that there is an absence of questions of fact. It doesn't. They can't point and say, well, you didn't dispute that under CPLR 3212, they have an affirmative duty to rule out and to make a prima facie showing. And that was not done here. But certainly there are questions of fact either way, Your Honors.
This is not a medical malpractice case, counsel, correct?
That is correct. It's a nursing home. It's 2801D and an ordinary negligence case, Judge.
So it's a question about whether their action in light of her 30 prior falls were reasonable or not. The fact that there's two affidavits that disagree isn't reasonable, usually a factual question.
I would submit that it is a factual question, Your Honor. And besides that, we have an admission of the defendant's employee here that the bed was left in a heightened position. The plaintiff so testified.
Mr. Hudson.
Well, that's hearsay. I mean, I might be double hearsay in there. But.
I would submit, Justice Smith, that it is not, because it's an employee of the defendant and there was a regulatory duty to make that telephone call. It's an admission within the course of that duty, and it is an exception to hearsay. It is.
But there's a dispute as to what that person denies making the statement. But I guess that's a factual question in your view. But the bottom line is the two affidavits that we have, I hesitate to call them expert affidavits because it's not a malpractice case, but they're two affidavits about what doctors in situations believe was reasonable in light of. This isn't a case where we're worried about foreseeability. It's just a question about what reasonable steps were or were not taken. And you believe that's a factual question for the jury?
I believe it is, Your Honor, and separate and apart from the expert affidavits, there are admissions on the interventions that were applicable to this person who was at the highest fall risk and who had a very heightened care plan there were regulatory standards that require this to be revisited that are imposed by the state.
But it's not their job to protect her from any falls. It's pretty obvious, given her conditions, that's difficult. It's a question about, did they take reasonable steps in light of her fall history? And your assertion is that is purely a factual question.
I believe that's correct, Your Honor.
Mr. Hudson, I'd like to take you back to the argument about the height of the bed.
Yes, Your Honor.
Unless I'm missing something, to me, that looks like a bit of a red herring. That is, who cares what the height is? Your argument is there's questions of fact about whether guide rails under this circumstance were necessary and whether pillows or bumpers should have been applied. Whether she fell from 2 feet, 1 foot, or 6 feet, it has to do with the extent of the injuries. It doesn't really have anything to do with liability, correct?
That is correct, Your Honor. And
why do you spend so much time telling us about the height of the bed?
That was the focus at the trial court, Judge.
Okay.
And the trial court made a determination and on the record said, well, isn't that convenient? And I would submit that that's making a credibility determination that's separate and apart from whether the steps and the interventions were reasonable, reflects a judgment call that should not be made by the court, but must be made by the jury.
Okay, thank you.
Thank you.
Ms. Roll.
Good morning. Just a couple of points. I believe Judge Kern has it absolutely correct that the height of the bed is a complete red herring. In fact, Dr. Shog, the expert, spends zero time talking about the height of the bed. He doesn't even say that the height of the bed had anything to do with the allegations at issue or proximate cause. And I would submit respectfully that the trial court found here the proximate cause was the primary issue. The expert of plaintiff did not at all address proximate cause. While he may have identified deviations of sorts that should have been put in place, at no point did this expert comment on how that could have causally related to the injury. He fails to address the expert affidavit of Dr. Bragman, who speaks about the internally mediating factors of dementia, the disease process, how this person operates on a daily basis, and how despite all efforts that could have been possibly taken, nothing could have reduced the risk of falling to zero. And in fact, despite the reasonable efforts taken, she did have a fall, which resulted in
that your client took all reasonable efforts to prevent this woman from falling. Isn't that a jury question as to whether they were all reasonable efforts?
Your Honor, I would submit respectfully that this is still a negligence standard for which they must determine proximate cause as well as deviation and tie them together. So whether or not there is a question regarding deviation, they still must follow the standard and address proximate cause. If there is a question regarding whether or not those reasonable steps were appropriate, my expert takes the further step to state that those pillows would not have changed the outcome here because this individual could have sat up, walked around the pillows.
Israel, that's where I need help. I did a word search and that's as far as I got with respect to pillows and bumpers and things like that. I didn't see that anywhere in your expert's affidavit. Do you happen to have a page reference I can pull up real quick?
Well, what I can say to you is this, Your Honor, is that pillows and bumpers were never addressed in the Bill of Particulars. What my expert did was go through line by line of the Bill of Particulars and address the various allegations alleged. For the sake
of clarity, there is no mention of the pillows, bumpers, and that issue in your expert's affidavit, correct?
Those words exactly correct. However, she does state that the steps that were taken were appropriate, that the restraints are not something that can be used in a nursing home short of a doctor's order, which would be a medical malpractice standard. There's no allegation here that a restraint in the bed should have been used. There's no allegation here that a bariatric bed should have been used. There's absolutely no allegation, as I recall, that pillows, cushions, wedges, those specific terms should have been used. Instead, it's a generalized failure allegation for which Dr. Bragman took every appropriate step, I believe, and would respectfully submit to anticipate what it is that perhaps plaintiff was referring to, even though plaintiff plaintiff never specifically articulated it. So
But surprisingly, the affidavit from the other doctor doesn't agree that all reasonable steps were taken. I agree the affidavit from the other doctor doesn't address the public health issues at all, and you agree with that.
yes, Your Honor, their expert namely says that cushions should have been provided, a bariatric bed should have been provided, and restraints. However, that expert never says in what form or fashion those pillows and restraints and bariatric beds should have been used. He never takes the step to further tie that to how that would have prevented any form of injury. There is no causal relationship. It's a conclusory statement here or there indicating that they should have been in the bed and then at some point they would have prevented this injury.
Thank you.
Thank you.
Appellate versus County of Erie. Okay. Go ahead, Mr. Targia.
Good morning, Your Honor. May it please the court. My name is Anthony Targia. I'm here representing the County of Erie. This is an appeal concerning a denial of a motion for summary judgment from the lower court concerning a death case arising out of the November 18, 2016.
I think we know the facts.
All right.
Of your 5 arguments, which one do you wish to lead off with?
Well, at the outset, I just want to make one thing clear for the court, that I'm here representing the County of Erie. The sheriff is not a defendant in this case, neither is any deputy of the sheriff or any dispatcher of the sheriff. And of the 5 arguments I make, I'm going to concentrate on the special duty argument, which I'd like to outline for the court. And as far as the other arguments raised, I will rely on our papers. So with respect to the special duty argument, that analysis under Valdez and Cuffey, and more recently Denicky, which was decided by this court in October of 2020, requires that 4 elements be met. The first being an assumption of a duty by a promise or an action or instructions given by the municipality.
Of those 4, which one do you believe does not exist?
Well, 3 of the 4 don't exist. The only one that does exist is one point of direct contact between the municipality and the individual decedent.
Counsel, that's if we accept your argument that the county is not responsible for the sheriff, dispatchers, Murphy, and others. What if we don't accept that argument?
Well, those individuals, the dispatchers, Murphy and Giannetti, they are employed by the sheriff, not the county, and they are not parties to this litigation.
Okay, when I call 911, which is a county system, who do I end up talking to?
When an individual calls into 911 Central Police Services, that call is in.
Miss Shields, right? And Miss Shields sent him to Murphy. And Murphy made him certain promises. He was told when he called the sheriff's office to call 911. Isn't that correct?
No, that's not correct, Your Honor. Respectfully, the call was made. The call in this case was made by Mr. Abate to Erie County 911. The 911 call taker answered that call and then transferred that call to the Erie County Sheriff.
That reflects the first call that Mr. Abate made at 111 when he calls the Erie County Sheriff's Office, receives a recording that says, if this is an emergency, call 911. And he thereafter calls 911. He gets talked to by Shields, who transfers him to a sheriff's dispatcher, who is not a deputy, is a civilian employee. And that civilian employee doesn't announce, as I understand it, oh, I work for the sheriff and not 911 or not Erie County and proceeds to make certain assurances to the person. We'll do what we can. We'll add you to the list. And then later at 6:40 says, we'll see what we can do. You're saying he didn't justifiably rely on those. Now, you might have an argument. I'm not sure what else he could have done if he didn't stay in his car.
Your Honor, respectfully, the only contact with the Erie County employee was that of a 911 call taker.
Yeah,
What that
by
call
your
taker-
argument that Murphy and the other dispatchers are not covered by the county. Who do they work for the sheriff?
Yes, Your Honor. They work for
They
the
are
sheriff.
not deputies.
They are not, but the Public Officers Law, Section 18, pursuant to 2 separate resolutions of the Erie County Legislature, provides for the defense and indemnity, not only deputies, corrections officers, but also all employees of the sheriff under those agreements and resolutions. So in the event that they had been sued, they would have requested defense and indemnity from the county under Public Officers Law, Section 18. That was not done here. They are not defendants in this case. So the analysis has to be restricted to the contact with the county, which amounts to a single call to the Erie County 911 call taker. The call taker, once receiving the call, transfers that call to the jurisdictional agency appropriate to
Okay,
the call.
so what your argument is, as soon as that happened, then the county's absolved of everything.
Well, the 911 call taker has fulfilled their responsibility in transferring that call, whether it's the city of Buffalo, whether it's Lancaster Police, or in the case of Denicky, the town of Cheektowaga Police Department.
Okay, I think we have that argument. Anything further?
Unless the court has a question, I will rely on the papers.
Thank you. Mr. Fitzgerald,
Can't hear you.
you have to unmute yourself. You're muted. You need
How's
to,
that?
there you go.
Better, there you go.
Thank you, Your Honor. I apologize
I
for
thought
that.
if I talk louder, that would make it.
Okay, I'm kind of a low-tech person, Your Honor. Everybody knows that, who knows me. But we struggle with these things. I'm Brian Fitzgerald. I represent Jacqueline Abate, the widow of Donald. And I want to focus on some of the issues that Judge Niemoyer just raised. What's interesting about the county's motion for summary judgment in the court below is that they basically took the position that there's only one contact by Donald with anybody from the county, and that's with call taker Shields. His subsequent contacts with Murphy and Grazik and the things that they did don't matter because somehow they're deputies, and they're deputies solely because they work for the sheriff. We set forth all of the definitions of these jobs of these people, all the dispatcher definitions. And we cited the 4th Department's decisions in Johansson and the Metcalf cases, which have held that the Sheriff's Department is not a separate unit or department or entity from the county. The Sheriff's Department is the county. So even though Mr. Targia phrases these people as employees of the sheriff, they are employees of the county. Now, because the county limited their motion for summary judgment to the lack of promise and reliance with respect to the first call with Shields, they didn't argue that there was any discretionary judgment or judgment calls by anybody else involved. They didn't argue that the conversations between Abate and Murphy somehow didn't amount to promise and reliance. And we cross-moved on those issues. And we set forth at length in the court below and in our appellate briefs the multiple instances of negligence on the part of how Murphy handled that call and also on the part of the other actors involved. Gang, who calls him at 9 o'clock to check on his welfare, doesn't leave him a voicemail message, and Grazik, who at 9:08.
There's a question about whether any of those other people could have created reliance, but there's no question based upon Murphy's 3 distinct statements that you believe there's at least a question of fact on reliance. you believe you've established reliance.
We believe we established promise and reliance, and we argued in our cross motion that those conversations Mr. Abate had with Murphy constituted promise and reliance, and that's in our cross motion. Please look at the county's opposition to our cross motion in the record at pages 1449 to 1455. They do not oppose that argument of promise and reliance. It is unopposed in this case. Therefore, promise and reliance has been established, and there are just multiple instances of negligence on the part of Murphy, Gang, Grazik, Janiti, and Whitus. And even going back to his first call with call taker Shields, whom the county clearly admits is a call taker, we believe that she was required to perform ministerial functions. There's a standard operating procedure number 11, which required her to interrogate the caller, to determine the nature of the call, to classify the call. What she did, if you read the transcript of that call, was as he began to speak, she interrupted him and said, "Oh, so you're in the ditch. You're in a ditch." He was not in a ditch. He was trapped in his car. He was halfway on Broadway and in danger of being hit by a plow. So the ministerial act she failed to perform, which didn't require any judgment, it's a ministerial act under the procedure, is transfer that call to Lancaster Public Safety Answering Point, who could have dispatched police or fire. Lisa Gavin, at around the same time, gets a call from Jennifer Taylor, who's stuck on Broadway about a mile away. And Lisa Gavin, a call taker at the county, did so dispatch that call. And Jennifer Taylor was saved. There's an affidavit in the court below submitted by Tracy Shields. She never says, "I was exercising judgment or discretion." There's no affidavits in the court below by Murphy or Grazik that they were exercising any judgment or discretion. So for the county to argue that these were matters of judgment or discretion and thus immunity attaches, it just doesn't hold water. This case, if you think about it, is a lot like the DeLong case. In the DeLong case, and some of us who are old enough to remember it, here in Erie County, this was a case in Kenmore, Victoria Boulevard. Someone was breaking into DeLong's back door. She had to call 911. This is 1978. 911 was new then. She couldn't call the Kenmore Police Department down the street. She calls 911, explains the situation, and she says, "Come right away." The dispatcher says, "Right away." That ultimately, by the New York Court of Appeals, was held to constitute promise and reliance. What happened in that case was they got the address of Victoria Boulevard and sent, but there's Victoria in Buffalo, and sent the police to Victoria in Buffalo instead of Victoria in Kenmore. So it's a wrongful location dispatch. That's exactly what's going on in this case. What's so hard for me to believe in this case is that Erie County, when it put in the enhanced 911 system in the 1990s, began to tout the system as one there where they can identify.
I think we're aware of that, Counsel.
I'm sorry?
We're aware of that.
So they knew or should have known at all times where he was. All they had to do was tell anybody involved. Grazik, this becomes not a matter of judgment or discretion. Once they start to take the affirmative action.
You've already made that argument.
Thank you, Your Honor. I could go on, but it sounds like Your Honor would like me to conclude, so I will. I thank you all very much. And I'll rely for the written arguments in our brief. Thank you.
Thank you. In the matter of R.W. Burroughs Grantor Family Trust. Okay, Mr.
Morning.
Burrow.
Good morning, Your Honors. I'm not seeing Mr. Roshan. Should I wait for him?
Oh, no,
Your
he's
Honor?
here. We have
Oh,
him.
he's there. Okay. There's a little bit of a delay. I'm sorry. Like the prior lawyers, Your Honor, I'm not terribly technologically sophisticated, so excuse me.
Trust me, I'm not either.
Well, may it please the court, Your Honor. My name is Gerard Brew, and I'm the attorney representing the appellants, Michael Lengvarsky, the trustee of the subject trust, and Marcia Burrows, who is appearing in her capacity as guardian for the minor children, who, because they're minors, I won't use their names in the proceeding, but certainly they're listed in the papers we have submitted to the briefs, Your Honor. Your Honor, I'm going to leave for our briefing primarily the issues about the disputes of fact that would have precluded the trial court from granting summary judgment to the petitioners in this case. And I'm instead going to primarily focus my remarks today on the various grounds on which the trial court could have dismissed the petition, and we are requesting that this court dismiss the petition in its entirety. The petition is premised entirely on SCPA 1502, and we would submit, Your Honors, that the petition actually seeks to transmogrify that statutory section, which has a benign purpose, to fill a position, a vacancy in the trust if there's no trustee serving. And what is going on here is an effort to turn that benign mechanism into what we would view as a weapon to insert persons who don't have a beneficial interest in the trust to become involved. In our briefs and in our reply brief, we cite the case of the matter of Schuyler.
Mr. Brew?
Yes,
Brew,
Your Honor.
It's still morning. Good morning. Just as a practical matter, with the death of Mr. Burrows and the estate being established, et cetera, all of this information with respect to the administration of the trust is now squarely within the discretion of the surrogate, correct? I mean, you know that there's lots of case law out there that talks about the discretion of the surrogate. So it's really in the hands of the surrogate. Is that the overall perspective we should have?
Well, Your Honor, not necessarily. This grantor trust was created before his death and is not part of his testamentary estate. It's an irrevocable trust created separate and apart from proceedings relating to his estate. There is, in fact, a probate proceeding pending involving his will and events of that nature. But that's the very nature of an irrevocable trust. It's not part of the estate and never would become part of the estate. So these proceedings don't fall within that discretion, Your Honor. These proceedings, in our view, fall within the terms of that trust and the statutory limitations. And I think SCPA 1502, as demonstrated in this Schuyler case, we cite primarily in our reply brief, Your Honor. It's a third department case from 2015. Actually, that case, Your Honor, did involve a testamentary trust, but under the statute and under that case, the same concepts apply. And that case stands for the important provision that SCPA 1502 is a very limited mechanism. In that case, the court declined to appoint a successor trustee or a co-trustee, even where, unlike here, the beneficiaries brought the petition seeking to appoint that co-trustee.
Brew, sort of to my point before, with respect to the surrogate's decision to essentially appoint a successor trustee under 1502 sub 1, effectively. The court has broad discretion in considering the various factors as it did with respect to the interest or time devotion of one trustee vis-a-vis the other. So all of that is governed by an abuse of discretion standard with respect to the appointment of the successor trustee, correct?
I'm not sure, Your Honor, I would agree it's subject to an abuse of discretion standard if there's been a failure to satisfy the elements of a statute. I think that would become, for example, if there were to be a trial in the case, and we were talking about the fitness of a particular person, for example, the proposed co-trustee to serve, those might be discretionary factors. But before you get to consideration of those factors, we first have to get through 1502. And the first and foremost element under 1502 is that, in fact, there is not a trustee serving who can execute the trust. The surrogate's court never made that finding. In fact, it fully recognized that Mr. Lengvarsky is continuing as a trustee of the trust. Once it looked at that factor, Your Honor, that the rest of the application failed under 1502 because there was, and this is addressed at length in the Schuyler case. Once there's a trustee serving and that trustee is operating in office, it no longer becomes a question as to whether or not a co-trustee or successor trustee can be appointed.
As I understand your argument, Mr. Brew, and both sides have done an excellent job of briefing it, I have to say. We have to look at whether or not the court exercised its power appropriately under 1502, whether it be 1 and or 4, depending on the analysis and what the issue is. We get that. We'll look very closely at the competing interests that the surrogate may or may not have considered. In terms of, you had a few procedural arguments. Is there anything that you wanted to address here today? And if you don't, that's fine. You can rely on your brief, but I was curious.
Your Honor, just another point with respect to 1502. I think the question here also involves section 1502.2, which is, even if you got past the first point, even if the court could have concluded that there was a necessity to appoint a co-trustee, and we submit, Your Honors, that there was no necessity to appoint a co-trustee because the trust in both Article 11 and Article 12 and Article 13 recites that either any trustee can act alone without the other trustees. In fact, the entire premise of this petition, which is, in my view, really an improper motion to enforce a marital settlement agreement. I'll get to that procedural point in a few moments, Your Honor. But the entire premise of this petition was that Marcia Burroughs could have acted alone to appoint Carolyn Zakowicz as a co-trustee. And yet, in an entirely contradictory manner, the petitioners are claiming that now there's a need to have 2 co-trustees. There is no such provision in the trust, but if there were, then both the Schuyler case and 1502 say that the court would then have to look to see whether there's a mechanism of trust by which a new trustee could be appointed. And that mechanism is that Michael Lindvarsky, as the remaining trustee, had the sole power to appoint. So that would be where the analysis would turn under the statutory analysis. And perhaps, Your Honor, not the case here.
Mr. Brewer, let me take you to the record, and I'm sort of taking you to maybe another issue. And again, if this was not part of your presentation, you don't have to humor me. But as I look at the record, the certified copy of the judgment that was filed with the court had attached as, and I'm going to get the exhibit wrong, but I think it's Exhibit E, the exact document that was presented later for Marcia, and I forget the last name, forgive me, Bowers, whatever, for her to execute. So she was required to either execute that Exhibit A, Exhibit E, attached to the certified copy of the judgment as filed with the court, or any other document presented to her by counsel for Mr. Burroughs, correct?
I believe that's the language that was there. Well, actually, that counsel was an attorney for both Mr. and Mrs. Burroughs.
Okay, but I want to make sure I got the record right, that it is attached, Exhibit E, in its form as Mr. Burroughs' counsel wanted, as certified, and there was no motion in the record to vacate that judgment, to say it was the wrong document. It's there in the record as part of the certified judgment, correct?
There are 2 resignation documents attached to that settlement agreement. One is the one that Marcia Burroughs signed, which is her contention in the family court. In fact, the family court decided this very question, Your Honor.
Well,
the one that she signed provided only for a resignation, not an appointment. There is a separate document that was later attached, according to the record, that would provide for the both resignation and appointment.
Well, is it that second document that you just described, is that also attached to the certified copy of the judgment that appears in the record that was actually filed with the court and was thereupon certified as accurate, or what's filed in the court?
I believe both are attached. Yes, Your Honor. And that became the subject of the proceedings in the family court that go to our procedural arguments of collateral estoppel.
Does the record reflect, Mr. Brew, anything with respect to the rationale employed by the court, the family court, in deciding that motion one way or the other?
There doesn't appear to be any written statement of reasons or decisions, Your Honor. No. There is a motion argument on December 16th, 2013. There is a proposed a mechanism to what I'll call settle the form of order. Counsel for Mr. Burrows submits a proposed order. Counsel for Mrs. Burrows objects to the form of that order.
We understand all that.
All right.
We're aware of that.
And then the court enters an order that does not contain that
Okay,
provision.
why don't you get to your other points, because you're running out of time.
Well, I think one point that has been made here is the argument that Mr. Burrows and his successors can't be precluded by the determinations made by the family court. Now, I know that in fact some of the justices of this court sit in the family court, and I would submit that as a matter of policy, that argument would create a very grave set of circumstances by which you'd have a family court that presided over a matter deciding issues relating to the divorce. The matter was presented. The family court judge never decided it. Excuse me, the family court judge decided it. And going back to the earlier question, there was no appeal taken by Mr. Burrows to dispute the family court's decision not to include a requirement that Marcia Burrows sign some other version of the trust document. And in fact, by that point, Marcia Burrows could not have signed another version because she was no longer a trustee. Under the terms of the trust, only an acting trustee could appoint a successor. But once the family court decided it, the argument that was made and apparently accepted by the surrogates court was that because there were other parties in the surrogates court proceeding, that decision isn't binding. In our view, that is not a correct analysis of collateral estoppel or res judicata, because
We're going to have to look at that very carefully.
I'm sorry, Your Honor.
We're going to have to look at that very carefully.
Yes, Your Honor. My only point there is that Mr. Burrows and his successors were bound. The rest of the people didn't matter. If Mr. Burrows and his successors were bound, that would end the analysis. I believe that those two issues could end the inquiry, and the petition could be dismissed on both that procedural issue and the substantive failure of the petitioners to comply with 1502. But if the court gets beyond that and concludes that there is a matter to be decided, then I would submit that this is the classic case of a host of factual issues that would have precluded a summary judgment in favor of the petitioners. There are, as we enumerate in our papers, and I certainly won't recite here because they're set forth, a host of factual issues that some of which were not even disputed by our adversaries. We would request, Your Honors, that this court look at the decision of the trial court and the effect it would have not only on this trust, but on all trusts, where persons who are not involved in the trust seek to insert themselves, and in fact, set forth in the record and not even addressed or considered on the factual disputes is the serious and substantial conflicts of interest that would arise when both the proposed trustee and the petitioners are actually adverse to the trust.
Thank you.
Thank you, Your Honor. Other than that, unless the court has any other questions, I would rest on our briefing.
Thank you. Mr. Rosh?
Good morning, Your Honors. Robert Rosh. I am appearing on behalf of the appellants, G.Ting Wang Burrows and Evan Breifus, as preliminary executors of the estate of Bill Burrows. I would like to lead off with the procedural issues that were raised by Mr. Brew in his papers on this appeal concerning the issue of standing and jurisdiction of the surrogates court.
Mr. Brew hasn't chosen to really focus on that, nor did they, I would say, perhaps even in their papers opposing or in their answer. So maybe you want to go on to a different point that Mr. Brew has addressed here today, if that's okay with you.
Yes, Your Honor. If I can point one thing out, not in my brief, but the point is that both the jurisdiction and standing issues were admitted by Mr. Brew's client.
I think we're moving on from there. Why don't you?
Okay. In terms of the appointment of Carolyn Zach Lukowitz, I think the court's decision is well-founded and well-reasoned. He relied on 3 basic criteria. He looked at the matrimonial agreement. He looked at the decedent's intent to appoint Carolyn as successor. And he also looked at the.
Mr. Rush, you don't need us to look at the decedent's intent here, given we have an irrevocable trust. I mean, you don't really need that, do you?
No, Your Honor.
Matter of fact, I
I'll
don't
move on
think
then. I want to point out that the court in, not a case cited in my reply, but it's a 2016 mandatory injunction case of this court, held that mandatory injunctions are only issued in extraordinary and drastic issues, and they're rarely granted. So the appellant is effectively telling the court, or like the court to believe, that because Mr. Burroughs, through another lawyer, made a motion for mandatory injunctive relief, and because he didn't meet that evidentiary standard, all other issues concerning the trust, concerning the matrimonial period, are effectively precluded. That's
you would say, Mr. Rush, you would say that, according to your argument, your brief, that they didn't carry their burden to establish that that issue was decided.
Yeah, I believe, Judge, my point is that the only issue presented before the family court was whether the Judge Hood should issue mandatory injunctive relief. That motion was likely bound to fail, but the failure of that motion should not bar the surrogate from hearing matters under 1502 about necessity, which we've clearly shown.
My point, if we don't know what the family court decided, why, whether it's mandatory injunction, whether the agreement shouldn't be enforced, when we don't know what it decided, you would say that the burden on collateral estoppel has not been met, correct?
And it wasn't waived either. It wasn't raised either by Mr. Brew's client before the court below. So there's a waiver issue, and there's a failure to satisfy both identity of parties and identity of issues. How can a party be precluded from litigating
I think we have that argument.
Okay, Your Honor.
Do you have anything further?
I'll only add further that in respect to Mr. Brew's comment that there are multiple issues of fact, court determined its decision in great part on the admissions of Mr. Lengvarsky regarding his unfitness to carry a burden of moving forward with this trust. You don't need a trial for admissions like that. It was clear enough in the record that Mr. Lengvarsky did far more than delegate ministerial duties. He effectively had nothing to do with the trust, and he delegated everything to Carolyn. Years after the complaint of transaction, it's a little bit incredible to argue that Carolyn is somehow conflicted out because she was the delegatee by Mr. Lengvarsky for all these years. And now, through new counsel, they're arguing, well, Carolyn's somehow conflicted. So I don't think there's even a credibility part of that. Beyond that, Your Honors, I would rely on my brief.
Thank you very much.
Thank you.
Clarence H. versus State of New York. Okay. You're gonna have to unmute yourself, Mr. Chamberlain.
There we go. I think I'm on now. Good morning, Your Honors. May it please the court. Patrick Chamberlain from Mental Hygiene Legal Service on behalf of the appellant Clarence H. This Article 10 case raises the question of whether the combination of antisocial personality disorder and a high degree of psychopathic traits is sufficient to meet the predisposition element of mental abnormality. It also raises weight of the evidence questions as to both mental abnormality and continued dangerousness. On the predisposition point, I want to lead off by emphasizing the fact that by law, under Article 10, predisposition has to be premised upon conditions, diseases, and disorders. That's right in the statute. And it's important to be precise about this when we're talking about the indefinite loss of someone's liberty potentially under Article 10.
Mr. Chamberlain, you know, we're well aware.
I understand. I emphasize it here because of what the trial court did, Your Honor. I think it's significant here because in this case, the state's expert, Dr. Scarpelli-Dwyer, made clear at page 92 of the record that she only diagnosed 2 conditions, diseases, and disorders in this case. And those were ASPD and psychopathic traits or psychopathy, depending on which score you look at. And despite that, the trial court went well beyond that. She also made clear when she was asked, both at page 69 of the
Counsel,
record.
if we just had the antisocial personality disorder and the condition of psychopathy, isn't that enough by case law?
I think the case law is pretty well split on that, Your Honor. There's numerous cases going both ways on that. It's a thorny issue still in the courts in New York. I've cited numerous cases. Opposing counsel has cited numerous cases. I think what matters is looking at the record evidence in each individual case. So even if this court were to conclude that that it's enough to meet that minimum threshold of legal sufficiency, that still doesn't mean that in every individual case, the proof will establish.
And discuss that in this case. What kind of behaviors did they find here to establish that he should be remain incarcerated?
Well, sure. And Your Honor, respectfully, the focus in terms of this initial question of whether he's predisposed to sexually offend in the first place, again, doesn't speak to behaviors, but rather what are the diagnoses? Diagnostically here, I think the evidence with respect to the ASPD and the psychopathic traits showed that there's considerable overlap there. The record evidence showed that the DSM-5 treats them as synonymous terms. You have the Court of Appeals repeatedly referring to psychopathy as an extreme form of ASPD. And you have both experts talking about the fact that even though psychopathy tends to encompass a broader variety of traits, it does capture a large portion of the symptomology that's identified with ASPD. So there's a considerable overlap there. And the Court of Appeals has said that there has to be a diagnosis independent of ASPD. I don't think the record proof in this case established that independence. I think it's problematic that Supreme Court went beyond those 2 conditions, diseases and disorders here, and looked at a history of hypersexuality and alleged traits of sadism. First of all, Dr. Scarpelli-Dwyer was twice asked to give her opinion on why she found a predisposition to sexually offend. That's at pages 69 and at pages 92 and 93 of the record on appeal. In neither case did she reference a history of hypersexuality or these traits of sadism. She talked about them at other points during her testimony.
70, which would be the next page after you just cited to, that the doctor opined that the petitioner's behaviors and traits related to his psychopathy included arousal, aggressive behavior, and entitlement, all of which predisposed him to the commission of sexually offending behavior. That's her opinion, and the court's entitled to rely on it, isn't it?
Well, frankly, Your Honor, I think that's describing the behaviors that result from it. Again, the predisposition inquiry is focused on the conditions, diseases, and disorders. Just because they manifested themselves in that way for him in the past doesn't mean it's been proven that they manifest that way for him currently, and doesn't mean that it necessarily meets the legal criteria, as I talked about before, in terms of being independent or distinct from his antisociality.
So
neither doctor diagnosed.
Just get it, Mr. Chamberlain. Justice Bannister's trying to ask you.
Counselor, there were instruments, measurement type instruments that they use, testing, interviews, et cetera, that actually, pinpoint what somebody's risk to reoffend are. And we had 2 of those. We had one by you and one by your opponent here, okay? One came out saying that he had a high risk to reoffend. Another, the opposite, said he had a moderate risk to reoffend. Why can't we rely on those type of that testing to show a predisposition and the need for further incarceration?
Well, I think respectfully that conflates the issues here. Certainly the risk assessments go to the second question, which is whether he can be considered so likely to reoffend if he's released that he needs confinement as opposed to SIST. So it does speak to those issues. Again, I think we need to be precise under the statute in terms of this first threshold question of predisposition being based on the conditions, diseases, and disorders, not the risk assessments, not something else.
As you have already mentioned,
Sure.
There's a lot of cases that go both ways, and you have to look at it at each individual case, and that's what we're going to have to do in this.
Yes, and just 2 brief final points that I wanted to address before I yield my time. The first is that Supreme Court relied upon in its decision and based its decision for confinement in part upon a precluded diagnosis. The parties here stipulated to the preclusion of paraphilic disorder related to non-consensual sex. Supreme Court quoted that and relied upon it in its decision in terms of justifying why Clarence H. Both has a mental abnormality and needs to remain confined. That was a reversible error in and of itself, that Supreme Court relied upon that and that it factored into its determination. And the final point I just wanted to make in response to the state's brief, which is the state seems to argue or insinuate that because Dr. Green candidly sort of recognized that Mr. Hargrove could benefit from additional treatment, could benefit from the supervision of CIS, somehow that contradicted or undermined her opinions. Frankly, that's just not fair. In these cases, that's a universal truth. Any of these individuals under Article 10 could benefit from treatment and could benefit from CIS, but that does not mean necessarily just because they could benefit from that, that the doctor is compelled to find that they meet the legal and psychological criteria. So there's nothing inconsistent about that. And I'd ask the court to reject that particular argument. Thank you.
Thank you. Go ahead.
Good afternoon, Your Honors. This case, as I think the court has identified, really presents a straight up battle of the experts, as you've seen multiple times. There's no thorny issue for this court to decide as a matter of law. With respect to combination, this court and every other department of the appellate division have routinely considered combinations that include traits. Just to borrow one of the components of the combination here, which is sadistic traits, among those sadistic traits is an admitted arousal on Clarence H.'s part to the infliction of pain and fear on innocent victims. Under my adversary's reasoning, he would have the court just pretend that that doesn't exist, and that's not what the law says to do. With respect to psychopathy, this court just last year in Glen T, in a procedural posture identical to this, upheld a finding of continued mental abnormality where the combination was, unlike here, limited to ASPD and psychopathy. So the question really isn't, can ASPD and psychopathy predispose an individual to commit sex offenses? It is, does it? And that demands that the court look at the evidence in front of it, which Supreme Court did. And as to that question, our expert created a very lucid picture of what's going on with Clarence H. here. There were two psychopathic traits in particular that she focused on. One was a hypersensitivity to perception and a resulting need to assert dominance. The second was a sense of entitlement to sex. And this caused Clarence H. to lash out in aggressive ways when he was confronted with women who made him feel apprehensive. He lashed out in a sexual manner. Now, certainly, Supreme Court could consider Clarence H.'s admitted deviant arousal to causing pain and fear as to why this was one of the ways that he lashed out sexually, as opposed to general physical violence. And with respect to hypersexuality, I disagree with my adversary's characterization of the evidence. Now, we'll say our expert said that it is not as strong a factor as it had been several years ago because he's been in CNYPC, but she nevertheless said that it is a factor. You could find that on page 60 of the record. And when he was in the community, his sexual appetite was described, well, self-described as insatiable. So all of these factors together are ample to support Supreme Court's finding. And if we look at what Clarence H.'s expert said, Clarence H.'s expert admits, I believe this is on page 158 of the record, that psychopathy helps to explain why he committed his offenses. That to me is a pretty important admission. Her opinion is not based on how this combination of conditions affects Clarence H. personally, but how Clarence H. affects the general member of the population. And that is not the Article 10 inquiry. Supreme Court was well within its rights to credit our expert over Clarence H.'s expert. With respect to OSPD, I just want to note that that argument is unpreserved. There was a stipulation that allows for the use of behaviors. They did not object to the stipulation. They did not object to any of the testimony. We don't think that it was inappropriate in any event. We believe that any reference Supreme Court made to it was in explaining among the reasons why it rejected the testimony of Dr. Green, namely that she didn't listen to Clarence H's own admitted deviance. With respect to control, we have an individual who is now on, I believe, his 7th annual review. He's been in CNYPC since 2008, and he's made very little progress. The root cause of his sex offenses consists of his overpowering need to assert himself as a dominant individual. And just this past cycle, we saw manifestations of that, as Supreme Court have found throughout the state in similar circumstances. Supreme Court found here that the community is simply not the appropriate place to be treating this kind of behavior for the first time. He needs to make more progress.
Okay, we'll look at that. We'll look at that carefully. Anything
Your
further?
Honor, if I could raise one final note, this was our final point in our brief. I just want to be on record that the state does not endorse Supreme Court's commentary about chemical therapy. Our argument is really just rooted to the judiciary's role. We don't think that there's a dispute to resolve anymore.
I think we all know that.
Okay, fair enough, Your Honor. Thank you.
Thank you very much.
Thank you.
Robert Owen Lehman Foundation. Okay, Mr. Dowd.
Thank you, and may it please the court. Because the Robert Owen Lehman Foundation's undisputed tax returns show that the foundation does not own the artwork and is stopped from arguing the contrary, venue in Monroe County was never proper.
So because they admitted it from their tax return, you're saying that establishes their acknowledgement that they don't own it?
That is correct. That's a statement to the government. We don't own it.
All right.
And if we focus the court on what the tax returns actually say, there's one.
Excuse me,
interrupt?
Joseph is asking a question.
Now, in your brief, you cited the Angelilio case. I hope I'm pronouncing that correctly. Second Department case.
Yes, Your Honor.
And they spoke on this topic just back last July. Let me read to you what they said. That plaintiffs did not include the diamond's value in its filings with Italian tax authorities does not stop them from asserting ownership now. Tax estoppel is applied where a party's subsequently adopted litigation position flatly contradicts express assertions. But the omission of an asset leaves all questions in regard to it open. How do you respond to that?
We've addressed that in our reply brief, Your Honor. And the issue of whether an omission can be used. And we do that at page 14 and 15. We've collected the cases where omissions were used.
Okay.
I believe it was at that point, or maybe it's in our opening brief. I apologize. We've cited a line of cases showing that omissions, as well as actual statements, can be used. I found it. I apologize. This is at page 20 of our opening brief. So we've cited a line of cases showing that both assets listed on a return couldn't be disputed as estate assets. And then we talk about where assets aren't listed. So it's both the
But the
omission.
court in its decision specifically said why it didn't believe that they were stopped, because the court seemed to say, based upon what counsel had said to them, they were not part of the filing because the plaintiff did not consider it appropriate until title was settled. The court's entitled to rely on that, and the court tells us why they didn't apply tax estoppel here.
Right. Well, either way we slice it, the statement to the court that it was not appropriate to list it in the tax return shows that the foundation doesn't own it. Under the law, you have to list assets. So you can list it as either an exempt assets or a non-exempt asset.
We'll look at that. We'll look at those cases. We'll look at that very closely.
Thank you, Your Honor. So it's really, the tax returns answer a number of the core issues. Does the foundation
central issue that you're relying on for most of your argument here today?
Yes, Your Honor. I would agree that that's our principal argument, and it goes to a few different issues. It goes to the issue of standing. It goes to the issue of whether or not an evidentiary hearing should have been held. When we filed the objection to venue under CPLR 511B, we've cited case law that shows in the Fourth Department, there's no discretion. You have to hold a hearing if there are disputed facts that relate to standing, and that's got to be decided at the outset. So we think that there should have been an evidentiary hearing on those issues right at the outset. And the court...
The standing under 511 is concerned. There seems to be no dispute that the foundation's principal office is in fact in Monroe County. You're not disputing that?
Oh, no, not at all, Your Honor.
Okay, so ordinarily that would be a proper venue.
Well, Your Honor, if you don't own an object,
I understand.
That
relates. It all seems to go back to tax estoppel, doesn't it?
No, that's not an estoppel argument. Let's say, for example, we lose on estoppel. What are we left with this 511B inquiry? There's a disputed issue of fact. So when under CPLR 511B, should that disputed fact have been decided? The case law shows us that there should have been an evidentiary hearing on those disputed facts at the outset before anything else is considered. So that's
that would be to determine standing or ownership.
Whether venue is proper. That's the
would venue be proper if they can demonstrate ownership? If
they can, yes. CPLR 511B says once we, the objectant, have raise a prima facie dispute, the burden shifts to the party establishing venue to put forth admissible evidence showing that venue is proper.
And the evidence they put forward is that we're a corporation and our principal office is in Monroe County.
No, Your Honor, it's the ownership of the asset. So they would have had
the ultimate issue in the case, isn't it?
Well, the
ownership of the asset
of the corporate location is not disputed. What is issue?
But what Judge DeJoseph is saying, that's the prime issue is the ownership. If you're talking about the venue, I'm missing something here.
Okay, so if this foundation never accepted a gift,
okay,
there's no venue in Monroe.
I get all that. All right.
Okay, so that's the core factual issue that needed to have been determined at the outset. And the reason this is subject to de novo review is that CPLR 511B is not discretionary. In other words, if the evidence that we put forth prima facie shows that venue was not proper in Monroe County, the trial court was either had to weigh the evidence put forth by the foundation and determine that indeed venue had been established, or in the alternative, held an evidentiary hearing.
Okay, you said that several times. Okay.
Right. So instead, the trial court said, well, they have said that they decided not to put it in their tax return.
Okay, we get that too. All right.
So
I guess
Didn't
we
the
have your
affidavit-
argument then.
Didn't the
So that-
affidavit of Robert Lehman claim that he was the owner of the artwork prior and that he gifted it to the plaintiff and that the plaintiff's office was in Monroe County?
Well, the problem with that line of analysis is Mr. Lehman is not a party to this action. So
No, but he claims he had ownership and that he gave it to the plaintiff who is a party to this action. You're saying that that isn't enough you want to make a final determination on ownership on an issue of venue? That just seems inappropriate.
no, Your Honor, was there a gift established? Yes or no? Did the foundation get a gift of this? It has nothing to do with the underlying dispute over who owned the artwork. It's one of those threshold inquiries that you just can't get past.
Okay,
So-
I think we have your argument.
Okay, all right. So if the gift wasn't completed, there's no standing. Moving on to and then the tax returns also go to
I think we already have your tax return argument. We've got that.
All right. Documentary evidence. All right. Then moving to the first file doctrine. What happened here was that there was a statement from Mr. Lehman saying the matter is out of my hands, it's with the FBI. Then he sues in Monroe County. If we look at the complaint, the relief sought in the complaint are order requiring title, declaratory judgment, and injunctive relief. Now, those declarations are merely advisory opinions and they're not ripe. The case law shows that a tort is really what underlies the first file doctrine. And this court's jurisprudence looks at the county in which the tort was alleged. And what we have here is a classic exception to the first file doctrine called anticipatory declaratory injunction.
You're talking about a race to the courthouse? Is that what you're suggesting?
That's exactly the second argument in our brief, is that there was a race to the courthouse.
There are two problems with that argument, however. Now, bear me out here. First, the race to the courthouse, parties have been negotiating this issue for over 2 years. So I didn't really see anybody sprinting to a courthouse in 2 years. And secondly, this issue, whether the matter is heard in Manhattan or Monroe County, the procedural and substantive law is the same. It's not like one party ran off to a different state to get a more favorable substantive law ruling, or to a foreign jurisdiction, for example. So you're all talking about the law of the state of New York, whether the trial is in Monroe County or the trial is in Manhattan. So this race to the courthouse doesn't seem to fit. The exception to the first to file rule doesn't seem to fit here.
Your Honor, we would contend that it does for a number of reasons that we cited in our brief. If we look at the underlying substantive law, a claim for
We will look at,
sorry,
which obviously we will look at. I'm
yeah.
just going to warn you, your time, you only have a few more minutes left. So.
Yes, Your Honor. The underlying substantive law of conversion requires that a conversion plaintiff must have a demand and a refusal. So Mr. Lehman didn't actually refuse. He said the matter is in the hands of the FBI. He never communicated back, the matter is in the hands of the FBI and I'm going to refuse your claim. So he never actually refused. He kept saying, I would like to settle. An actual refusal would have given the true plaintiffs in this action, the Rieger heirs, the opportunity to commence an action in New York County. And the cases that analyze the anticipatory declaratory judgment actions, in those cases, the court looks at that true underlying tort and would urge that the court to properly apply the first file doctrine would have to analyze the tort of conversion. Our third point goes to the failure to state a chain of title. Here, the court is asked for a declaration where the plaintiff has not alleged any chain of title. It's simple.
The plaintiff does allege this, however, though. The plaintiff says that Lehman Sr. bought it legitimately at an auction in England in 1964, gave it to Lehman Jr. Lehman Jr. Had uninterrupted, peaceful ownership of this item for over 50 years. No one ever challenged my title to it, and then I donated it to the foundation. So that's the chain of title they're relying on. It's not like there's nothing here.
Well, no, Your Honor, that's not a chain of title. That's saying I'm a good faith purchaser, and therefore I should be entitled to rely on my good faith purchase. Instead, they're using that good faith purchaser defense under New York law as a weapon against Holocaust victims. And if we look at the Guggenheim versus Lubell case.
So this is just a venue motion, isn't it?
No,
we're not getting to the merits of the underlying action. I'm confused by that.
I'm confused. I'm going to tell you, Mr. Dowd, that's where I was going with this earlier. I am very confused with your argument because I thought we were just discussing the venue issue.
Well, no, we've also dismissed for failure to state a claim. And we've said that to state a claim for legal title under New York law, you have to allege actual legal title. So they haven't done that. They've alleged a provenance gap of 47 years. And they've said, oh, we can't find evidence for that provenance gap. And they've asked for it.
When did you move under 3211A7? Failure to state a cause of action. When did you, that was your so-called second motion, wasn't it?
Yes, Your Honor.
The first motion was not under A7. So is that second motion even properly before us?
Yes, Your Honor. We've argued that when they filed their first complaint, one of our clients was not listed as a party. Therefore, the second motion doesn't violate the single motion rule.
What about, I know something, we'll look at that very carefully, but your time is, you have 1 more minute left. So you're done whatever you need to.
Thank you. Reversal and dismissal are warranted on these facts on a de novo standard of review. This action should be dismissed or in the alternative transferred to New York County. Thank you.
Thank you. Go ahead. Mr. Owinski.
Yep. Good afternoon, Honorable Justices of the Appellate Division. My name is Zach Osinski, attorney at Nixon Peabody. I represent the Robert Owen Lehman Foundation. May it please the court. I think this court has correctly teed in on both the standing issue first, and I was pleased to see that we raised the issue of the Angiolillo case, which I was planning to
ask you about tax estoppel for a moment, if I may. Now, you bring this action seeking a declaration that you're the owner of this property. If you stand by that declaration, why didn't you file a tax return to assert it?
Well, the omission in the tax return was based on the foundation's advice from their tax professionals, which the lower court properly noted. And again, regardless of whether or not the foundation improperly or properly did not list the disputed piece of property on its tax return, that alone does not mean the foundation does not have standing to bring this lawsuit. And in response to their original motion to dismiss and demand for improper venue, the foundation submitted a sworn statement of Robin Lehman demonstrating he gifted the drawing to the foundation's acceptance of that gift, and the consignment agreement with Christie's, which shows that the foundation is the current owner of the drawing. And also, I think it's worth noting that while appellant here is arguing that we don't have standing to bring this lawsuit, and that the first to file doctrine should not apply and this matter should be transferred to New York County, in their New York County action, appellants actually allege that they name the foundation as the current owner of the drawing, and they allege in their complaint that we are the current owner. They have not amended that complaint, and they continue to assert that we are the current owner in the New York County action, while arguing on this appeal that we are not, and we are therefore deprived of standing. I think for all these reasons, the tax estoppel argument borders on the frivolous, and at a minimum, they have failed to demonstrate their, failed to carry their burden that the foundation lacks standing as a matter of law.
Anything further?
I guess the only other point on the standing argument, I would like to point out that appellants seem to allude to cases where there were omissions in tax returns. I'm not aware of any cases. I've examined their cases. I don't think there's any cases where there was an omission on tax return, which led to a tax estoppel being applied to prevent a party from asserting ownership. And regardless, none of those cases are standing cases. None of them are motion to dismiss cases. And as the court held in Rizzo, the tax estoppel applies to where a party tries to contradict express assertions that it previously made in its tax filings. And we respectfully submit that the court should follow the First Department approach and deny appellant's appeal on the standing issue. Moving, I'm sorry?
Anything further?
On the first to file issue, I just would like to address a couple of points that they raised in their argument. Again, I think as this court pointed out, this was not a classic race to the courthouse. There were ongoing negotiations for close to 3 years. And we did not bring suit in a distant forum, as was the case in all the cases that they allege. All of them involved a dispute where someone tried to lay venue in New York, and there was a race to a distant forum in places like Maryland, California, or Texas. Here, it's just a dispute over whether New York, as opposed to Monroe County, is a proper venue. These are not distant forums. And the anticipatory document. Okay.
Anything else?
I guess assuming the court is satisfied with respect to the other chain of title arguments that they raised, I think it's clear to the court at this point that this appeal is all about venue and appellants who desperately don't want venue to lie in Monroe County, despite the fact that it's proper here, and despite the fact that they cannot establish that any convenience of material non-party witnesses would be benefited by a change. And as all their arguments fail to establish the foundation lacks standing, and that the foundation should be deprived of its choice of venue, which this court has recognized as afforded great weight, the appeal should be denied.
Thank you very much.
This court will stand in recess.